Okay. What we finished yesterday, the Gemara concluded that initially we tried to establish the Mishnah, it should go follow the position of Rabbi Lozer, who holds 80 Mesira Karsi. So we said, what is 80 Mesira Karsi? If you have a document, what gives the viability to the document? Is it the witnesses that signed in the document? That gives it its validity and its viability? Or is the document being transferred in the presence of witnesses? Without witnesses, everybody agrees, unless it's the handwriting of the owner transferring to the buyer. But if it's just a piece of paper, it has no witnesses signed on it, or no witnesses witnessed the transfer, it means nothing. So our question is, Rameir says, what gives it its viability and its validity? The document is signed. When witnesses sign the document, it becomes a legal document. Without signatures, it's not a legal document. It has no value. Rameir. Whether it's get, whether it's a divorce document, whether it's a monetary document. Rabbi Lezer says no. The witness that signed on the document have no value. But what gives the document value? They have to witness the transfer. If they witness the transfer, that gives it value. Otherwise, so we discussed yesterday, the Torah says testimony has to be oral testimony, it cannot be written testimony. So according to Rabbi Lezer, there's no such thing as written testimony. Because the concept of shtar, a document, never means witnesses signing on the page, on the document. Doesn't mean that. A document means a document which is, it has the information passed over, transferred in the presence of witnesses. Okay? We discussed this yesterday. So we had a problem. According to Rebbe Lezer, it holds 80 Mesira Karsi. Now what gives it its validity? That it's witnessed, the transfer is witnessed by witnesses. So it says Rebbe Gamliel legislated that every divorce document that's given should be signed by witnesses. Why? Because if later the woman presents the document that she was divorced, the husband may claim it was never given in the presence of witnesses. He'll say she wrote the document herself. So what happens if the witnesses died? The witnesses who actually witnessed the transfer, they died, or they went overseas. So if you're not able to locate the witness that witnessed the transfer, how could she remarry? She could never remarry. Or if she does, it'll always be questioned, it'll be contested, she never had a right to remarry. So how do you deal with it? So he says, whenever whenever the divorce document is given, it should always be signed by witnesses. So if she has a signed document, it's clear that originally the husband had it signed, and she was given that document. So that will prove that she was given a legal document. So the question is, but how do we know it was given in the presence of witnesses? Right? According to Rebbe Lezer, unless they witness the transfer, it doesn't. So he says, because we could presume if the husband had given to her, which is clear from the witnesses, that tells us it was done properly. And what's a proper divorce? That the document is given in the presence of witnesses. Right? That's how we explained it yesterday. But the problem is, according to Rebbe Lezer, the witnesses on the document seemingly are not valid. It's not valid testimony. If you say the Torah says what gives a document validity, it's the witnesses sign on the document. So although normally written testimony has no value, but within the context of a shtar, a document, the Torah says that's the exception. But according to Rebbe Lezer, there's no exception. Every document never has witnesses. So how do we reconcile this? Okay? So we said what we said yesterday. That on the Torah level, not, but factually, if they're witnesses, that creates the Anan Sadi. That's what we said yesterday. There's a famous riff, which we didn't mention yesterday. Rabbeinu Yitzchak Al-Fasi. The riff says that Rebbe Lezer argues with Rameir regarding, he says, 80 Mesira, he agrees, he's saying 80 Mesira is sufficient. He says, Af 80 Mesira Karsi. 80 Chasima, witnesses signing a document definitely gives the document validity. Everybody agrees. A signed document is a legal document. Even Rebbe Lezer concurs. He agrees to this. He's saying a chiddush. He's saying something novel. Even if they don't sign, the document has no signatures, as long as it's witnessed, that's sufficient. Rameir says 80 chasim, you must have witnesses on document. Without that, it has no value. That's Rameir. Rabbi Lezer says, I disagree. I agree, of course, if you have, even if it's witnessed, that's sufficient. So he's not arguing. He's not arguing that witnesses, there's no such thing as witnesses who sign on a document. There is such a Torah law. Torah law is a document is created through witnesses signing on a document. That's shtar. However, he says, but I'm of the opinion, even if they don't sign, it assumes the status of a legal document, it's a viable document. Just by being witnessed, the transfer being witnessed, that's sufficient. See, the Rif says, in addition to witnesses signing, even if it's just witness, that's sufficient. Wait a second. Wait a second. Wait. Okay, let's first establish that's the Rif. So according to this, it's a whole different understanding. So now, the problem we had of Mipim and Piksov on oral testimony, as the oral cannot be written, we asked, if you say they're arguing, Rebbe Loza says there's no such thing as witnesses on a document, we had our problem. So witnesses when sign a document, that's written testimony. It's not oral testimony. Torah says the only testimony which has any value, which is equivalent of evidence, is only if it's orally transmitted. But if it's written, it's not. So if that's the case, we have a problem. So how do you have a shtar? You have to say it's all rabbinical. It's all rabbinical. But if you say, according to the Rif, the way Rabbeinu Yitzchak Alfasi says, no, Rebbe Loza does not argue Rameir. He agrees with Rameir. There is a concept of shtar, witness signing the shtar. Torah says that is not written testimony. That's the equivalent of oral testimony in the court. A legal document is equivalent of witnesses testifying in court. However, he says, but even if you don't have that, you don't need that. As long as witnesses witness the transfer, that's sufficient. That's the Rabbeinu Yitzchak Alfasi, the Rif. Okay? The Rambam, and that's where the Rambam rules. So when we say Rebbe Lezer was enacted that every get should have witnesses on it, Rebbe Glil, when he enacted that enactment, because we're concerned the witnesses may go overseas. So now the witnesses sign, what is that? That get is a Torah get. That's a Torah divorce. Because Rebbe Lezer is only saying it's not necessary, but Rebbe Lezer says it is necessary. Because in case the witnesses should die or go overseas, she's going to have a problem. So David, how should it be written? It should be written, it has to be signed.
The Rebbe Lezer holds that the signing is valid. Then how does he hold that not signing is valid? If we're saying that Rebbe Lezer holds that
again, let's repeat it. Okay. Let's repeat it, and you can answer a question one of two ways. You answer a question, or you realize the question is not a question. We're going to answer it now. It's not a question. Okay? Okay, exactly. Until now, we're saying, what gives a document its viability? Is it because it's witnessed? You have written testimony. You have witnesses who signed the document. It's like very often you go to a wedding, and so you have witnesses on the ksuba. It's a monetary document, the ksuba. So very often they ask, you mean the groom doesn't sign the document? He's out. He should sign. Because the person doesn't understand what exactly the document is. They say seemingly the chosim has to sign also. Doesn't have to sign. It's like a lender, a borrower has a document. He doesn't sign it. It's not an IOU. He has a witness. He takes that. Gives it to the lender. So that document, same. That's the ksuba. The ksuba is no different. Okay. Now, what gives the document its legal status? Its viability as a viable document that has the ability to terminate the marriage, right? As a get. Of course, you have to have the information. After you have the information, now it's witnessed and it's signed. Does that give it its viability? So Rameir says definitely that gives its viability. Anything less than that is meaningless. It has to be an integral. The witnesses have to be an integral part of the document. So it has to be physically part of the document. If it's not a document. Rabbi Lezer says, I disagree. What you're saying, definitely, it does give it, according to the Rif, Rabbi Yitzchak Alfasi, but it's sufficient that as long as witness the transfer, knowing the document with that information has been given over, that immediately gives it its viability and has the ability to terminate the marriage. So Rabbi Lezer is lenient, is being more lenient. I agree, but it's not necessary. Even if you have less than that, that's sufficient. That's what Rebbe Lezer is saying. Okay?
What about the case of exceptional circumstance where the man wants to divorce his wife? There's no
person needs gold to make a piece of jewelry. He says, I have iron. I declare this iron as gold, and just consider it when you make the piece of jewelry, it's gold, not iron. You understand? It's not reality. The Torah says the only way you can terminate a marriage, you have to give a document. It has to be signed. It has certain type of information on it. It has to be given from the husband to the wife. Otherwise, the marriage continues.
But the intention is...
So, what your intention is?
But there's
Let me ask you,
many-
you intend to put on tefillin, you don't put on tefillin. Did you fill the mitzvah of tefillin? But I intended to. What's intention, You know how many people are in Gehenna with good intended people? No.
But it's like wanting to go to a shul, and for some reason you are...
That's onus rachmana patre. See, that's something else. If a person is in a situation that's beyond his ability, there's no claim against him. There's no claim. Here, we're not talking about a claim. You have to terminate the marriage. The only way you could terminate the marriage, you have to give that kind of document. If you don't give that kind of document, the marriage continues. You haven't severed the relationship between the husband and the wife. It's fact.
I have a question. So, in that case, in this gentleman's case, it's not for a lack of intent, but for a lack of resources, right? It's not for a lack of.
You want to do a deal.
Sure.
Unless you have a certain amount of money, you can't do the deal. But I want to do the deal. But unless you have the means, you're not going to do the deal.
Yes, but the deal is consecrated by the
Could I say,
existence
a person
of monetary value.
a person has a medical problem. He needs surgery, an operation.
Sure.
Okay? And the doctor he doesn't have the equipment to do the operation. The person's going to die from whatever the problem is, or is going to suffer from whatever ailment. Could be corrected, but he doesn't have the ability because he doesn't have the surgical tools, equipment to do the surgery. So what happens? I wish I could, and the patient says he wish he could have the operation too. So what happens? He has this predicament. This predicament doesn't change. It gets worse. Marriage is a bond. How do you sever that bond? It has to be severed only with this kind of document. If you don't have the document, you can't sever it. So the bond remains intact. So she's a married woman.
So I think it's interesting that you bring up the analogy of someone who's suffering and who's ailing and needs surgery compared to someone who needs a divorce, right? In the case of someone who needs a divorce, right, they both are suffering.
Not necessarily. Not necessarily.
Well, one or the other.
Each one of them wants out of this marriage in the worst way.
Sure, but you'd agree that it would be the opposite of joy, that a marriage that is defined by joy wouldn't require a divorce. You'd agree that that's the case.
I'll give you an example. An illegitimate Jew marries a legitimate Jew.
Okay.
It's not a permitted marriage, but they marry. They're married.
Okay.
They must divorce. The law, because the Torah says they're not permitted to be married, because one person is illegitimate, what we call mamzer, and the other person is a legitimate Jew. And they have to divorce. It's okay. They love one another, but they have to divorce. How do you sever that marriage? And you don't have the scribe, you don't have the witnesses, you don't have the ink, you don't have the paper. They're not able to. So the marriage continues. If this woman should commit adultery, it's an adulterous act as much as she's supposed to divorce. It doesn't make a difference. Right? That's the reality, because the marriage was never terminated.
Rabbi Meir, how do we know that he is operating on the basis of a derisive with his position, as opposed to he is putting in a drabamon?
Okay? Again, there are two ways you can answer a question. Okay. When the Torah says v'kosav, okay? The Torah says a get, the document only assumes the document has to be written lishma. Has to be written with a specific intent for this couple that's being divorced, the husband and the wife. If you have identical information from another person, could you use that document or not? Rameir says that you could use the document. The Torah says because of law, it must be written specifically for her. That means what gives the get its viability? It has to be written specifically for this particular couple. The husband has to write it for his wife. So if someone had a wife with the same name, but yet Rameir says if you find the get in a trash can with the identical information as the person needs, you can take it out and have it signed on his behalf. Because when Torah says kosav means the completion of the document. What is the completion of the document? When it's witnessed. Witnessing when it's signed. But until that point, it's an ordinary piece of paper with information on it. No. No.
If they're just witnesses that...
No, because he explains because it means it has to be written.
Well,
What is it? Does it mean? Are we speaking about the completion of the document, or it's the writing of the document? They're arguing how to interpret the word. What does because of
The
mean?
Rabbi Eliezer holds the writing of the document. So that writing of that document that's found
That
in
what
garbage,
that determines it to be a valid get or not. Because of law, the writing has to be written specifically for her. Has to be written.
Lishmo.
So if it's written for another woman, although the names are identical,
but if there are two witnesses who witness that transfer of that get that's found in the garbage,
it's not
can,
valid.
It's
Because
still written for those people because
no, it wasn't written for the right couple. It was written for another couple.
He would not hold that written as
But it's another argument here. It's two different arguments. One is the argument when the Torah says when you write, it has to be written for her. What does written
And
mean?
Rameir holds
Does it
that.
mean completed for her, or does it mean initially the actual writing of the information?
Rameir's assigning this for her.
Rameir says without witnesses, it has no value. So when it says the get has to be written for what's get? Get means the effective document. It only becomes an effective document when you put the signatures on. Without that, it's not an effective document.
Let's recall that those two witnesses who witnessed that transfer of that get would be the same as the two signatures on the get from Rameir.
Yeah, but this is correct, 100%.
So then why could Rabbi
But I'm
Eliezer hold
explaining
that
to you.
from the garbage is good?
Of course, the Torah says. So what does because of mean? If Rabbi Eliezer holds that you don't witnessing the transfer is sufficient, no writing, but the Torah says it has to be written lishma. So what does written lishma mean? So it means the text has to be written lishma.
Specific.
You're right. The witnessing the transfer is like the witnesses in the document. That gives it its viability. But Rabbi Eliezer, but you still have to read the words. It says it should be written on her behalf. What does that mean? The actual divorce is in the presence of witnesses. That gives its viability. What about the recording of the information? What has to be the intent? It has to be written specifically for her because that's what the words say. Because of law, it has to be written for her.
According to this, it seems that Rabbi Eliezer is saying, yes, you're right about the signatures, but even if you just witness the transfer.
Sufficient.
So, according to Rich, you could pull it out of the garbage can, according to Rabbi Eliezer, and have to sign it.
No. You can't do it. You see, the argument's like this. Rameir says, the argument of Rameir and Rabbi Eliezer is not limited to get. It's any legal document, a monetary document. A monetary document, what gives it its viability? Rameir says, you have to have witnesses in that document. Rabbi Eliezer says no. So the argument of Rabbi Eliezer and Rameir is not limited to get. It's a concept. They're arguing what gives a document its legal status of a document.
What's the Rich?
The Rif saying Rabbi Eliezer agrees that witnesses in the document do give it its legal status, but it's not necessary. It doesn't have to be.
So that's a step down. According to the Rich, Rabbi Eliezer
It's more lenient. It's more lenient. You don't have to meet that criteria.
So then the signatures are the ultimate importance. If you don't have it, then witnessing the transfer is okay.
It's sufficient. It's sufficient. So that exactly. But it's not limited. It's not limited to the divorce
What
document.
happens why is it that if the signatures are paramount according to the Rich?
No, they're not paramount. No, it's not paramount.
It's just
It's
valid.
it's the
So
same.
It's not a step down.
No, he's more being he's being more lenient. It doesn't have to be this way. If you have a broader playing field,
I agree.
it's broader. It doesn't have to.
You don't need
It could the document could assume its legal status either A or B. Rameir says only A. So whose position is a broader position? Rabbi Eliezer is a broader position. It's not only A, even B. You're able to give the document its validity, even B.
So that means A is preferable. But B
Why is it not preferable? According to Rabbi Eliezer, it's not preferable.
It's the same.
It's the same, but you A, because what Rabbi Gamliel had said. What happens if the witnesses now can't be located? But that's a technicality.
Why
That's
do we need Rabbi Gamliel if Rabbi Meir is right?
because we rule like Rabbi Eliezer. We rule like Rabbi Eliezer. We don't rule like Rabbi Meir. You're right. Since we rule like Rabbi Eliezer, so you don't have to have it legally. You don't have to have a signature document. So a person will give the get in the presence of witnesses, sufficient. But then we have a problem. What happens if we can't locate the witnesses later? The woman has a problem. So to avoid that problem, we say witnesses should sign on the document, which would be proof that she received the document from the husband.
So Rabbi, according, if we start with the Rip's understanding, how do we know that Rabbi Elazar would not approve of a get that wasn't written lishma, that was signed lishma?
Okay, this is what I said. The argument of Rabbi Loza and Rabbi Meir is not limited to get. It's not limited, even a monetary document.
Even a monetary
Wait. Monetary has no relevance to lishma. No, it doesn't have with an intent. A borrower writes a document, and he says, Shimon, I'm borrowing $1,000 from Reuven. That's what he writes in the document. And originally he thought the lender would be Reuven A, Shimon A. Turns out it's Reuven B. And he gives that same document to the second individual, who originally he didn't think would lend him money. Is it a valid document? Of course it's valid. It has no relevance to the Shema. It's just proof of intent that whoever lends me the money, I'm bound by this document as a debtor to a creditor. Right?
So that's good.
It's good. It says no
They
lishma.
would say good, and Rabbi Elazar would also
According to the Rif. According to the Rif.
According to the Rif, they would
Would
both
be-
say good.
It's good.
Because the signatures on the document were good.
The signatures.
Because
But according to Rabbi Loza, what about if you give that document in the presence of witnesses?
Good.
No signatures.
Good.
oh, they're still good.
But according to Rabbi, it has no value. Has no value. I mean, it has no value as a documented loan. An undocumented loan, yes, because you lend me the money. But as a documented loan, in terms of properties being lien because it's a documented loan, it has no value. According to Rabbi, you have to have signatures that it should be documented that the properties are lien to the debt. According to Rabbi Lazar, witnesses witnessing transfer because that's a documented loan, the properties are lien to that debt.
But without the witnesses, is there any way that Rabbi Elazar would say fine?
Yes? No witness, period?
No witnesses, period.
The-
Just no witnesses on the
Sign.
transfer. Just witnesses on the
Fine,
document.
100% fine.
So he would agree with Rabbi Meir then on that point.
No, what do you mean would you agree? He says it's fine. Ramiro says it's nothing. If there's no witnesses signed on that monetary document,
There was witnesses signed, but there was no witnesses to the transfer.
Rabbi Loza says it's fine. Not a problem. There's no problem there. According to the Rif.
According to the Rif, and according to the Rif, Rabbi Meir would say it's fine too.
That's his position. It's always his position. That is his position. Witnesses always give it. Without witnesses, it's nothing. Has no validity whatsoever.
There's just another method, if you will.
That's Rabbi Loza.
There's another method.
Right. But I'm saying what we gain according to the Rambam, now without Reb Chaim, we're able to understand Reb Chaim. Reb Chaim made a differentiation between a document which is written purely similar to a receipt, just as proof of purchase, or that was the mechanism through which the transfer took place. You're able to purchase a property by giving a deed. When you give it that document is not just proof of purchase. That document was the means of transfer. When it's the means of transfer, that document is a Torah document. Now you can use that document as proof. Because the witnesses in that document, if it's a legal document, witnesses and the document's that's not called written testimony. Because there's a concept known as document. But if it's written initially only as proof of purchase, there's no such thing on the Torah level. That's rabbinic. That's purely a rabbinical document. So on Torah level, that's written testimony. But to be able to protect the buyer, where he had bought it, not the transfer place through money or some other means, he has to protect himself. So he legislated a document, which is only rabbinical, that if it's signed, that's sufficient proof that he purchased the property.
One, so why would you need to find an X couple find an X number? According to the WIP, you would only really need one or the other. One would be rabbinic and one would be D'oraisa. Correct? In other words, we're trying to work out who the mission goes like.
Now we're going like Rabbah. Rabbah says it has the reason why the shliach has to say it is because lishma, that it has to be written with the intent. Rabbi Lazar says the funny nechtav. We're talking about the lishma. Wait 1 second.
Oh, that would go on the lishma.
We're talking about see that's unrelated to what we're discussing now.
Not on the signed document.
We're not even if it's a signed document, right? It still has to be written.
If it wasn't signed,
Yes.
according to the WIP,
Yeah, but it's
Rabbi
but
Elazar,
it's brought from
going on
overseas.
the lishma aspect.
But we're talking about factually, he's delivering a document that's been signed.
Fine. And what about we discussed a case yesterday where witnesses were invalid according to Rabbi Kalatsky?
No.
It wouldn't.
We asked the question.
We asked the question.
There's no question.
The Gemara wanted to know.
According to
According to the Rif's understanding.
before we go with the Rif, let's review it, otherwise people will be confused. The Gemara had said that even though Rabbi Loza does not need witnesses on the document, but Rabbi Gamliel legislated that you should have. If those witnesses were not valid, let's say they were Korban Posel, everybody agrees. Even though the document on the Torah level is valid, because witnesses witness the transfer, and they were valid witness. But if the witnesses signed that document were either related or not qualified to testify, the document is disqualified, is invalidated. Why? That's called Mezuyit Mitocho, because there's an inherent defect in the document. So once there's that defect, why? Because you may rely on that testimony. If you have witness in the document, you rely on that testimony, and that testimony is not valid testimony. Because either it's a relative, or it's a person who's not qualified to sign on the document, correct? So therefore, even though on a Torah level it's valid, but that's called it's a defective document, we actually invalidate it.
Transaction is undone.
Rabbinically undone. Yeah, the Raisa. No, they say she's not permitted to marry.
They're right that it's not available. False witnesses of that.
But there were 80 Masira. We're talking about there were 80 Masira. He had witnesses witnessed the transfer from the husband to the wife, but the witnesses who signed were related.
Right.
You don't need them really, right? Because what terminated the marriage? According to Rabbi, for sure, it's nothing.
It's totally the rights is invalid.
It's the rights it's invalid.
Right. Okay.
According to Rabbi Loza, rabbinically.
Right.
Why? Because you're going to rely on those witnesses, and then they're not reliable witnesses. Okay, right? That's what we said. That's simple. Now, so Tosas asked the question. So therefore, what about according to Rabbi Loza if the witnesses did not sign Lishma? The qualified witness didn't sign Lishma. He says that's the equivalent of having non-qualified witnesses signing, because there could be confusion. As the witness didn't sign Lishma, he may actually write the get not Lishma. Therefore, that's considered witnesses who are not qualified to sign. We invalidate the document. Okay, that's what we had till yesterday. Now, what are you saying about the Rif?
How does that fit with the Rif?
What's the problem?
The Rif saying.
Because that's Lishma. It's Lishma. We're talking about the document was witnessed, the transfer was witnessed by witnesses. Now you have witnesses sign on it, and they did not sign Lishma. Why do we invalidate? According to the Rif, what gave it its viability in this context?
The giving.
The giving. Okay, good. Now witnesses signed Shlo Lishma.
Why should we invalidate it?
Because once, what about if it would have been written Shlo Lishma? There'd be a problem. Once we're tainting the document with Shlo Lishma, we invalidate it, because what happens if the person would have written it not Lishma? That's called, therefore, that we see it as a defect. It's a defective document. Although the witnesses weren't necessary, they weren't necessary. Doesn't make a difference. Once it's seen as defective, we invalidate
The way
it.
you explain the Rif is that it's not necessary, but if you have it, it's fine. But there, it really isn't necessary. You could.
Doesn't make a difference.
It
But
shouldn't really-
but it's because of the confusion. We're concerned about the confusion.
So the last question is, if the Rif is correct, how does he understand Rav Ashi looking for a third source? If the Rif is correct, then
Yeah.
the more should you going to look for a third source for the fourth condition?
Wait a second. Because Rav Ashi holds it to the right side of the Rabbanon.
Well,
The agent, when he delivers the get, when he says that's on the Torah level, right? That's Rav Ashi, and Rabbi Yehuda holds it is on the Torah level. Both have to be addressed.
So both Reb Meir and Rav Elazar can't be
Right? Cannot be for that, because
because
according to the other answer, it's only rabbinically. We're validating rabbinically. Correct. Okay.
What about the following scenario? A man writes a get with witnesses, Lishmo, everything is absolutely correct. And then, 5 minutes later, in front of the witnesses, he dies.
And he never gave it to the woman.
He never gave it
Okay,
to the
let's talk. Personal rights and insurance policy. $10 million policy,
Yeah.
signed, sealed, and he was about to sign, and he had to pay the premium up front. He died right before he had the money in his hand. He died. He never paid the premium. Does his wife collect the $10 million? Okay. If he would have given it, she would have.
So
Okay.
what prevails is the delivery.
The Torah says you must give her the get. Put it in her hand. If you don't put it in her hand, she's not divorced.
Right. So delivery is the most important.
Yeah.
The closing.
Okay. Okay, there's an interesting Tosas over here. Tosas wants to say that according to Rameir, we said 80 chasima karsi. The witnesses who sign on the document, they give it its viability and they cause it to be a legal document. Now, a marriage under the chuppah, David, a marriage under the chuppah, it has to be witnessed by witnesses. If it's not witnessed by witnesses, it's not a marriage. Okay? Now, why? Because it says, Al pi shnai medim yokum davar. The Torah says that what gives the marriage validity, it has to be witnessed. The act has to be witnessed. The act of marriage. So even though in terms of the document, what gives the document its viability and its value is the witnesses on the document, but that's not the act of divorce. The act of divorce is the husband giving the document to his wife. So just as the marriage has to be witnessed, based on the principle of Al pi shnai medim yokum davar, that it has to be witnessed to give it its value, it has to be witnessed by witnesses, like the marriage. So the divorce, so there are two aspects. There's creating the document, which is the mechanism, and then there's the process. So to create the mechanism, which is the shtar, which is the document, Rameir says you have to have witnesses in that document. So that you've created. But what about now when it's transferred? You have to have witnesses witnessing the transfer. If there's no witnesses, even Rameir would agree it's not a marriage. Wait. So it comes out, it's interesting. According to Rebbe Lozer, Edi Mesir Kasi does two things. It gives it its viability, and also they're witnessing the divorce. It's two things. It's the document and its viability. Right? According to Rameir, even though you've created the document through witnesses, but what about the act of divorce? Therefore, according to Tosas, Rabbeinu Tam, the divorce has to be witnessed. If it's not witnessed, it's not a valid marriage. So it comes out, even according to Rameir, we have to say that when you have a document which is witnessed, and she has it, there's a presumption aspect. Maybe they weren't 80 Masiro, right? We discussed this yesterday. According to Rameir, the answer is we have to say there's a presumption. If the document was written correctly by the husband, we assume there's a presumption that the process was a valid process, that he gave the get to his wife in the presence of two witnesses. That's what you have to say. Okay, we'll stop here.